Hello, everybody.
So, Mr. Legrone, and the Fabians, I see there's Jeff Fabian. I'm assuming that Susan's there on separate Zoom calls. So this comes on the calendar from last week. This involves a fence built along the property line or close to the property line. The fence was constructed by Mr. Legrone. They have adjoining parcels in that I believe, you can correct me if I'm wrong, it's not really pertinent to the decision, but the Fabians lot is unoccupied, but it had a lot of blackberries apparently. And the fence that was installed by Mr. Legrone a number of years ago, thank you. The blackberries, as blackberries do around here, were growing quite quickly. And they were up against the fence. Some of it was overhanging the fence. It looked like at some point, some of the blackberries were poking through the fence. When Mr. Legrone brought that to the attention of the Fabians, after some discussion, the blackberries were removed or taken off. At that point, the fence fell over. A portion of the fence, not the whole fence, but the portion of the fence fell over. Mr. Legrone brought this lawsuit against the Fabians seeking replacement of the fence. I heard testimony last week. There was numbers of pictures submitted by both sides. I was curious about a couple of things I wanted to look up, which I did. And I went back and reviewed all those pictures and ready to make a decision. And the decision is as follows. And so when Mr. Legrone put the fence up, that's your obligation to maintain the fence, certainly on your side of the fence and on the adjoining property side of the fence. If there are things encroaching on that fence or encroaching on your property, like overhanging branches or which we actually see that issue here both in small claims as well as on the anti-harassment calendar, you have the right and the obligation to maintain your fence properly to cut that off and cut off the overhang and trim branches from the other side of the fence to maintain your fence. With that in mind, also, I looked at my review of the fences, and I'm, again, like I said before, I'm not an expert on a lot of these things that come in front of me, but just looking at the fence and the condition of the fence when all this came about is along the bottom of the fence where it fell over, it was essentially rotted out, for lack of a better term. Now, was it? I don't think I can find it was rotted out as a result of the blackberries. The fence had been there for, my memory is correct, and my notes are correct, for 12 years. The fence has essentially reached the end of its useful life.
No.
And
8 years.
Although other portions of the fence apparently didn't appear to be rotted and that's just the state of the fence. But given the portion of the fence that was at issue here, I find that I'm unable to enter a judgment on behalf of Mr. Legrone against the Fabians, and that'll be my finding. They didn't have an obligation. They didn't, of course, neglect any obligations on their part, and this case will be dismissed and it'll be a finding for the defense, and that'll conclude the case here.
You're wrong on the date. You said 12 years.
Okay. Well, how many years was it?
I told you last week it was 8 years.
Okay, so it was 8 years, but nonetheless, given the condition of the fence, combined with, like I say, you certainly had the opportunity or could have, cut that stuff back over the lifetime of the fence, and so that's my ruling here today.
Your Honor, I can't trespass on their property to cut along the bottom of their side of the fence. Okay. And that's what I was told.
Okay, and so, well, you could. Okay. This is going to be my ruling here today, but I know this happens a lot. You could contact them and work out some sort of deal where you can maintain the other side of the fence, and that never happened. And that's going to be my ruling here today.
Okay. All right.
And you're all free to leave the Zoom call.
I'll be in contact with them.
We are on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case number 2024 SC1, Ariana Letterman, plaintiff versus Vanessa Jennings Harris, defendant. As this is a small claims court, this does come on for petition filed by Ms. Letterman, alleging that Ms. Harris owes her $4,056 for money spent to pay taxes on some property. Ms. Letterman, do you want to go ahead? I'll put you both under oath. If you'd both raise your right hands. Do you solemnly swear the statements and testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, Your Honor.
Thank you. Ms. Letterman, if you'd like to proceed to briefly state your cause for claim today.
So I was with Miss Jennings Harris's son for about 8.5 years on and off. We had gotten back together and he had reached out to me and said that his mom owed back taxes on this property that she inherited from her dad. And so I was eligible for a business loan, and whenever he had brought it to me, he had said that we were going to get the deed to this place and we were going to be able to fix it up, and ultimately it would be ours. So I went to my bank and I pulled a loan to present to Miss Jennings Harris for this business or this property. She paid the check, and a had went by, and I hadn't heard anything from my boyfriend at the time, which is her son, about the deed or anything. I really didn't know any details other than we were going to have this place for us to fix up. And so a couple months goes by and I'm asking him, like, what's going on? And he was just too intimidated, I guess, to talk to his mom about it. So I reached out to Miss Jennings Harris and over text messages and asked her, you know, what's going on with this place? Are we going to be able to get the deed? Because I wanted to start working on it and get the utilities in my name. And in order to do that, the business or the property had to be in my name. So I reached out to her about it, and the conversation just did not go well at all. And then probably about June, she had told me in the messages when I talked to her that it was just a loan and she would get me the money back. And so I said, okay, you know, that's fine. So we had agreed on, you know, doing payments, and she made one payment in June and one in July. And that was the last that I had heard. And she has me blocked on everything, so I couldn't reach out to her about any of this. So here we are.
And you and the boyfriend are still together?
No, Your Honor.
Okay. So let me see if I understand this right. You were dating the defendant's son, and the two of you found out that his mother was behind on some property taxes, and what, was she in jeopardy of losing the property?
Yeah, it was about to go up for auction.
Now, in the petition, you call it, is it TJ's Mini Mart?
Yeah. Sorry, yes, Your Honor.
And it's located in Severy, Kansas.
Yes, ma'am.
All right, well, that would give me jurisdiction. Is it an active working business at this time?
No, ma'am. It's been closed for quite a few years.
Okay,
Yeah.
and it was the boyfriend's grandfather he ran the business originally,
Yes, Your Honor.
and he passed on, and the business, or the property the business is on, went to the defendant, Ms. Harris. Is that right?
Yes, ma'am.
And because the property taxes hadn't been paid, it was a threat of being lost to tax sale.
Yes, ma'am.
Okay, so the boyfriend asked if did he ask, or did you volunteer to help with the tax payments?
A little bit of both. they had asked a couple other people, and I guess nobody would. So then he had asked me, and I was eligible for a business loan, and I saw a business opportunity and, somewhere that my kids could potentially take over. And so I just did it.
So you, in your own name, solely in your name, got this business loan?
Yes, ma'am.
And the lender didn't require you to own the property?
No, ma'am.
And you didn't have to put anything up in property? Did you put anything in writing with Ms. Harris that this would be a business that you could run?
No, not exactly. Whenever I had messaged her about, what was going on with the deed, because I had little details. All I knew was we were going to get this place together. We were delivering the check to his mom so she could pay it, and then the deed would be signed over, and that was that. I didn't know anything about a loan. I wasn't told really anything at all. My boyfriend had just asked me if this was something we could do, and I said yes. And to save this place, I mean, my dad was a good friend of Vanisa's dad, so I felt almost as if this was kind of meant for us. So no, but whenever I had messaged Vanessa about the deed, she kind of blew up on me and said she would get me my money, and pretty much that was that. So
she did not want to sell or give or transfer the property in any way, is what she said after the fact?
yeah, I don't believe so. No.
All right, but you gave her a one-time payment of $4,056, is that right?
Yes, Your Honor.
And you have received back two payments totaling $400, is that correct?
Yes, Your Honor.
So your demand for judgment is $3,656. But then you also put recovery of personal property plus court costs of $4,056. So where does the $4,056 come from if you've already received payments of $400? Which amount are you seeking recovery of?
Just the remaining balance of the 3,600. Yeah, I probably meant that just being the total of what it was. But yeah, she did pay me for two payments of $400.
All right. So Miss, is it Jennings Harris or Harris that you prefer to go by?
Harris is fine, Your Honor.
Okay, Miss Harris, then do you agree that she did provide a check for $4,056 to help you pay for your taxes on this particular property?
Yes, ma'am.
And do you agree that you've repaid $400 of it, treating it as a loan?
Yes, Your Honor, to a certain extent here. This has been quite an ordeal. I, by all means, did not have any idea what all was discussed between her and my son. Did not know that this was a loan.
What did you think it was?
Well, when the taxes came due, I've owned this property for many years, and I reached out to both of my boys and said, hey, do we want to keep this property? Do I want to look into selling this property? What do we want to do? They replied that they would like to keep it. I said, okay, this is what we've got to come up with. So in between that, my son came to me and said, we have the money. So I said, okay, are you sure that you guys want to do this? I went to him and said, are you sure this is what we want to do? So he said yes. And then that is when I received the money.
When he told you we have the money, who did he mean, or who did he indicate to you was we?
him and Ariana.
Okay, so you did understand that Ariana was helping put up the money, if not putting up the whole money.
Yes, yes, Your Honor.
Okay. So there's no dispute that she gave you the money and you believe she's entitled to repayment of that money?
Yes, Your Honor, she did put up that money.
Okay,
There's no doubt about that. I'm not contradicting that at all. She
Okay.
did have the check was from her. So yes, ma'am.
okay, yeah. And you agree that you've paid her $400?
Yes, ma'am.
So the
She came,
total, oh, go ahead.
I'm sorry. She had texted me. We kind of went back and forth with text that she was struggling to make the loan payments and that she needed to get these done. And so I told her I would get some money that I could do, get her some payments on this. And so I didn't want, she does have my granddaughter. I didn't want them to struggle. So I was giving her some money to help her out. Yes, ma'am. And the total was $400.
All right, so you agree that you still owe her $3,656?
I agree that is what's left of what was given to me.
All right, I am going to grant judgment to the plaintiff, Ariana Letterman, in the amount of $3,656 with 12% interest until paid. And court costs, what did you pay for court costs, Ms. Letterman?
I believe it was 65 and then 15 to serve her.
If my math is correct, that adding the 65 and the 15 is $3,736. That will be the judgment at 12% interest. When can you get this paid, Ms. Harris?
I will need to make payments on this. There's absolutely no way that I can come up with this in full.
Well, judgment is granted. Once a person takes judgment, they can use legal means to enforce that. And if you don't have that paid in full within 30 days, there are forms she can send and require you to fill out revealing your assets. If you don't do that, she can bring you back to court on contempt citation. So I would give you 30 days to get that paid in full. And then after that, it is up to Ms. Letterman to exercise her collection rights, some of which I've just mentioned. So if she wants to accept payments, she can work that out with you. If she wants to proceed with other methods, she can do that as well. So
Thank you, Your Honor.
that being said, we'll be in recess. You both are excused at this time. Thank you.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Be safe, be well, sleep sweet, and much love.